I'm going to talk today about the civilian criminal law procedure from the point of investigation through to trial and, if necessary, sentencing. So in criminal law, there are always going to be exceptions. So with nearly every example that I'm going to give, there will be exceptions, but this is just a general overview of what normally might be expected to happen. Normally, a criminal investigation is conducted by the police. That's not always the case. There are other agencies, such as Her Majesty's Revenue and Customs, such as local authorities, or private organisations such as the RSPCA. But normally, investigations are conducted by the civilian police. The civilian police will normally conduct an investigation, and that investigation will usually include an interview under caution. At the interview under caution, the individual will be cautioned prior to interview, and the caution is this: you do not have to say anything, but it may harm your defence if you do not mention, when questioned, something that you later rely on in court. Anything that you do say may be given in evidence. So this is the police's opportunity to put the investigation evidence that they have gathered to the individual for the individual to be interviewed about that in order for the police to gather evidence. The individual will normally make one of three choices. Either they will answer the officer's questions, or they will make no comment, or they will give a prepared statement. It may then be that the individual is released pending further investigation, or it might be that they are told that they are going to be summoned to court, or it may be that they are bailed, or they may be charged to court or kept for court. All of these options are available. So it may be that an individual comes to court either having received a requisition in the post, or having been charged by a custody sergeant and given a date to attend court, or it might be that they are physically taken to the court having been refused police bail. Either way, the matter then ends up in the Magistrates Court, and every criminal matter that is prosecuted in England and Wales starts in the Magistrates Court. Once a case is in the Magistrates Court, criminal cases may be divided into three categories. The bottom end of the scale are what we call summary-only offences. These are cases that can only be heard in the Magistrates Court. So an example might be common assault. Common assault can only be heard in the Magistrates Court. Next are offences that we describe as either way. These are matters that can either be heard in the Magistrates Court or at the Crown Court. So an example of an either way offence would be actual bodily harm. That can be heard either at the Magistrates Court or at the Crown Court. And finally, at the top end of the scale, the most serious offences are what we call indictable only. These are matters that can only be heard at the Crown Court. So to deal with those three in turn, a summary-only matter being dealt with at the Magistrates Court, the magistrates will want to take a plea. The individual will either plead guilty or they will plead not guilty. If they plead guilty, the matter will usually proceed to sentence. That may be with or without a pre-sentence report from the probation service. If they plead not guilty, the matter is very unlikely to be dealt with at trial on the same day. What will normally happen is the matter will be adjourned to be heard at a trial at a date to be set in the future, sometimes several months in the future. And at that Magistrates Court trial, 3 magistrates or a district judge will determine whether or not the prosecution have proved their case. The prosecution bear the burden. It is for the prosecution to prove beyond reasonable doubt that an individual is guilty of the offence alleged, and the magistrates will determine whether or not that is met. It's different from in the Crown Court, where the decision as to whether an individual is guilty or not guilty is determined by a jury. For either way offences, a matter first appears at the Magistrates Court. The prosecutor will usually indicate where the prosecution think the matter should be heard, whether it should be heard at the Magistrates Court or at the Crown Court. The defence may then give representations as to where the defence think the matter should be heard, whether it should be heard at the Magistrates or the Crown Court. And then the magistrates will determine where the magistrates think the matter should be heard. If the magistrates conclude that the matter is too serious for them to deal with, the matter then goes to the Crown Court. However, if the magistrates conclude that they will accept jurisdiction of the matter, it is then for the defendant to decide whether or not they will accept the magistrate's jurisdiction of the case, or whether they will elect for the matter to go to Crown Court. If the defendant accepts the magistrate's decision, the procedure is very similar to what I previously outlined for summary-only offences. If the defendant elects Crown Court, then the procedure is very similar to what I'm going to talk about now, which is indictable-only offences. So for indictable-only offences, they come before the Magistrates Court. They're identified as indictable only, which means the magistrates don't have the power to hear them, and they are then sent, either with or without bail, to the Crown Court. At the Crown Court, the individual will enter either a plea of guilty or not guilty. If they enter a guilty plea, that may be with a basis of plea, or it may require a Newton hearing, and then it will proceed to sentence, and sentence will be carried out by a Crown Court judge. If the individual pleads not guilty, then the matter moves forward for preparation for trial. That will include matters such as disclosure, defence statements, witnesses, preparing the matter for a trial. And the trial is heard at the Crown Court, presided over by a Crown Court judge, but there is a jury. The jury will be of 12 lay people, and it is for the 12 lay people to decide whether or not the prosecution have met the burden of proof, the burden being is it beyond reasonable doubt that the individual committed the offence. If it's not beyond reasonable doubt, then the jury should be directed by the judge accordingly, that if they can't be certain, then that should be a not guilty verdict. If the jury conclude that they are satisfied beyond reasonable doubt, or that they're certain, that they're sure that the defendant committed the offence, then the defendant will be convicted and the matter proceeds to sentence. The sentence is conducted by the Crown Court judge, not by the jury. Now, whether a matter is heard in the Magistrates Court or the Crown Court, there are then appeal procedures. In the Magistrates Court, if an individual is dissatisfied either with the sentence or with the conviction itself, in the Magistrates Court they can appeal. They appeal to the Crown Court, to a Crown Court judge and 2 lay magistrates. They appeal if it's on a conviction, because the conviction in the magistrates went against the weight of the evidence, or if they appeal against the sentence, the appeal is because they consider that the sentence was manifestly excessive. And ordinarily, that right to appeal is absolute. In the Crown Court, it's different. The Crown Court appeal process is different. That's then put forward to a judge sitting on their own at the Court of Appeal, judge at first instance, to determine whether or not an individual should be permitted to take the matter forward to the Court of Appeal. So in very brief outline, and as I said at the start, there are many exceptions. In the civilian courts, there are 2 court systems. There's the Magistrates Court and there's the Crown Court. All offences can be divided into 3. They are either summary-only offences, indictable-only offences, and either-way offences. In both matters, if an individual pleads not guilty, they then have a trial. In both the Magistrates Court and the Crown Court, it is for the prosecution to prove beyond reasonable doubt that the individual is guilty of the offence. If the prosecution can't convince either the magistrates or the jury that the individual is guilty beyond reasonable doubt, then the defendant is entitled to an acquittal. If the defendant is convicted, they are then sentenced either by the Magistrates Court or by the Crown Court judge.